It's going to vary by statute. So for most statutes, the answer is going to be there's a broader definition of what constitutes adverse employment action when we're talking about a retaliation claim than when we're talking about an underlying, say, like Title VII discrimination claim. And I think that's the clearest example. If you're bringing a discrimination claim, adverse employment action is going to mean things with a tangible diminution in your pay or a tangible obstacle long term in your career. So, for example, that's going to be things like demotion, cut in pay, taking away all of your management responsibilities, or out and out terminating you. When we talk about retaliation, the standard there is what the employer is doing, does that have a chilling effect on employees who are thinking about raising the same kinds of concerns? If it would have a chilling effect on a reasonable person, then it's more likely to be considered retaliatory in the context. It's more likely to be considered actionable in the context of retaliation claim. So that can include things like, for example, being placed on probation or being placed on a performance improvement plan, maybe being denied a bonus. There can be less catastrophic things that can happen in your career that would still give you a retaliation claim, but may not necessarily rise to the level of adverse employment action for purposes of an underlying discrimination claim.